first case on the 9 a.m. docket, State of Kansas versus Hunter Clift, case number 128226. Counsel, you may get assembled at the table, and Mr. Gillette, you can approach when you're ready.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas appellant in the instant case. I would again request 4 minutes for rebuttal.
4 minutes will be noted and granted. Thank you, Mr. Gillette.
The state will initially just note that we believe that the factual summary that's been provided here is fairly clear. There's not a lot of dispute about the facts in this case at this point.
When you say factual summary, you mean the factual summary of the court or the factual summary of the district court?
Not the factual summary of the district.
I thought that's what you meant. Okay, yeah. Go ahead.
The facts that were presented and as are argued in the state's brief, and the only question really here today is whether or not the district court reached the correct conclusion in determining that KSA 2163-32 violated the Second Amendment. As this court is well aware, the Second Amendment provides that a well-regulated militia, being necessary to the security of a free state, right of the people to bear arms, shall not be infringed. Historically, there are a number of ways that the possession and use of firearms can be regulated. In this case, the statute at issue here is KSA 2163-32, which was passed by our legislature and enacted in 2014. The statute criminalizes as a misdemeanor the knowing possession or carrying of a loaded firearm on or about such person or within such person's immediate access and control while in a vehicle, while under the influence of alcohol or drugs, or both, to such a degree as to render such a person incapable of safely operating a firearm. There are numerous statutes, or there are numerous exceptions and rules provided in this statute that render the statute inapplicable to certain individuals under certain circumstances. The state would begin its argument here by noting, as we do in our brief, that whatever analysis was being conducted here by the district court, it is unclear. But what is clear is that it was not the proper Second Amendment facial constitutional analysis, as is required by United States Supreme Court precedent and historical precedent from this court as well. Unless the court has questions to that end, I believe that at this point.
What do we do with that when the court suggests he's conducting a facial analysis, but then goes into as applied kind of scenarios, goes into overbreadth kinds of that is unrelated to a typical constitutional facial challenge? What do we do when there's this kind of one-off or even two-off analysis by the district court to reach its conclusion? Do we just ignore it and say you right for the wrong reason, or what's your suggestion here?
The state's suggestion would be to simply reverse and remand. Whatever course this court might feel necessary upon directing such a remand, the state would accept. There is also the possibility of right for the wrong reason, as is argued in the defendant's case here. However, candidly, I don't believe that holds up here. The defendant in their own brief points out at least two instances. There are notes that they appear to concede that the defendant in this case was actually in possession of a firearm. So based on that concession alone, the provision that the district court felt was unconstitutional here didn't apply. They do not dispute the fact that the district court here found at least two factual scenarios in which this statute would be constitutional. The defendant themselves then goes ahead and points out yet another in their example of hunters in western Kansas that place their guns in the bed of a truck, then get drunk and have a designated driver driving them home. Again, in a facial constitutional challenge, That is yet one more example of how the defendant cannot succeed on a right for the wrong reason claim here, because there are numerous examples of how this court can recognize sets of circumstances under which this statute would be valid. So basically, to conduct the correct test here, regardless of what happened, of whether this court just directs this a remand based on the record here to proceed with as applied or whatever other challenges may come up down the road, or whether this court determines that the district court's ruling here constitutes a finding that this statute is facially constitutional. I think that that could happen as well, because under the test from United States versus Rahimi, the correct test for a facial challenge is quite clear. It's not easy to apply, but it is very clear. This court has, and any district court should consider whether the statute is consistent with the principles that underpin our regulatory tradition, and consider
why don't you get to that? That was kind of because that's where I think, well, if we do get to that question, explain to me how the state has established that the statute is consistent with the historical tradition of firearm regulations. Sure. And how far how limited are we in looking at that? So kind of a general, what's your view here?
The state's view, and as noted in our brief, we would point to there are, I believe I put the state notes no less than 9 cases in its brief, as well as 2 more recent cases from federal circuit courts of appeal, in which the regulation of the possession of firearm by those who are presently intoxicated can be criminalized. To the state's surprise, even candidly, my personal surprise, one of those statutes is even from the state of Kansas, going all the way back to 1867.
In the history of that, our Kansas statute, and a number of these that you cite to were enacted years after the Second Amendment was drafted. So how, what's your view of how far, how general can we be in going back and looking at what corresponds with our tradition? That makes sense. But it's kind of, I think as I've read these cases, circuits have kind of struggled with that question, because some of these were adopted at our statehood, 1868, around in that time period. But that's 100 years after the Second Amendment was written. How broad, how general, how far can we go?
So I guess that I would say there are 2 things that I would say. I think we can go back as far as other courts have here, and in part, again, as we know, that does reach all the way back to the 1800s, the early 1800s, much less than 100 years later. And part of the reason that has been articulated for the ability to do that actually ends up being the 14th Amendment, which provided for equal protection. Because until that time, the Second Amendment was not being equally applied to individuals in this country. And therefore, courts have consistently allowed for reviewing courts conducting a facial analysis to go back until that 14th Amendment was ratified, significantly later, around the time that the cases cited by the state were being decided. And so I think that's how this court can consider the time frame here. In specifically, the state does want to direct this court to the Second Circuit's decision in James that collects all of the 7 of these historical statutes going back to the mid 1800s. There were several other cases noted going back to that same time period, including the very early 1800s, 1837. criminalizing those with alcohol addictions. The issue here is even narrower than that. The state would suggest we're not talking about just someone with an alcohol addiction. We're talking about someone that is presently under the influence of alcohol to a degree that they could not safely operate a firearm.
Well, I guess I want to get past the first step of the federal analysis, which we haven't established at this point in your case that the defendant was unlawfully firing his weapon, you know, or was anything other than a law-abiding citizen. I mean, I realize he was drunk, but, you know, or had the high blood alcohol content. But there's nothing else about that. I mean, he's presumptively covered by the Second Amendment, right? You can see that part.
Correct.
Yeah, okay.
However, being presumptively protected by the Second Amendment doesn't mean that it applies to you in every instance or circumstance. And that's what we're facing here, is the fact that he was presently under the influence of alcohol. It's in the record. His blood alcohol content was nearly twice the legal limit for driving a vehicle. And yet we're supposed to just believe that this is an individual that could operate a firearm. He can't operate a vehicle. This is an instance where the state would also know, and if I may, Your Honor, I recognize I'm out of time.
Go ahead, Mr. Gillette.
At no point did the district court or the defendant attempt to carry their burden at the second step to demonstrate that there is no set of circumstances that exist under which the act could be valid. The district court here found sets of circumstances where this act could be valid. The defendant, again, identifies yet another set of circumstances in which this act would be absolutely constitutionally valid. As a result, a facial challenge to the statute must fail. And this case should be remanded for further proceedings, at which point, you know, any additional challenges or remaining challenges regarding Section 4 or as applied challenges can be litigated properly.
Very quickly, how would you articulate with specificity the historical analog that would support a finding that there are circumstances in which this statute could be constitutional?
I would direct this court to the two federal cases. I think those are probably the most easily identified steps here. That would be United States versus Connolly, Fifth Circuit Court, that's cited at page 14 of the state's brief. And then
well, those are recent federal court decisions. I'm looking for the historical analog that you're relying.
Correct. And I'm citing to these cases, that case, and then as well the believe it was the Second Circuit case. I want to say it's James that's cited in the state's brief, because those cases collect the historical analogs, including the.
Well, are you pointing to any particular historical analog? That's what I wanted to ask you about.
I think there are 11 that are identified throughout those cases and identified in the state's brief that are all analogous.
All of them are analogous? I mean, they have varying levels of specificity.
Sure.
Well, give me your best historical analog from the state's perspective.
The state would initially note, in responding to Your Honor, we don't have to have a one-to-one equivalent. So that would be the first thing that the state wants to make sure that this court recalls. We don't have to have a dead ringer or a historical twin. So we've got to be close. I think the Missouri case, Shelby from 1886, clearly prohibits those that are intoxicated from going abroad with firearms. That's just carrying them in public. I think that's a good example. The 1867 Kansas statute that prohibited any person under the influence of alcoholic drink found simply carrying on their person a pistol is subject to arrest. Those are just two of the 11.
Can you point the court to anything that was contemporaneous with our founding, something that would be along the lines of the going armed laws or the surety laws?
So
In other words, if we were to hold you to a historical analog that was contemporaneous, can you still prevail?
yes, the state believes we absolutely can. Again, I would direct this court to James that collected 3 cases from the early 1800s. And I want to address this question. I appreciate the court's inquiry to this end, because in that case, they discuss a Massachusetts, Maine, and Rhode Island militia laws, all from the early 1800s that prohibited those, including those with alcohol addictions, from militia service. And they found that those are analogous and allow for the prohibition on the right to keep or bear arms. And those are important here because those were broader restrictions on the right to keep or bear arms than what is.
Were they really, or were they instead a restriction on militia membership?
They are broader. While it does discuss militia.
Well, it doesn't disarm individuals who are not members of a militia, does it? I mean, correct me if I'm wrong, but that's my recollection.
In James, they explain that that prohibition was sound as an analog for prohibiting those with substance use disorders simply from possessing firearms. And so, again, this is a proper way to look at it, because again, this statute is nowhere near as restrictive as those.
And yeah, that was part of my inquiry, and is kind of piggybacking on Justice Stiegel's questions, is what was a historical analog at the time of the nation's founding was regulating behavior that the government or people that were thought to be dangerous.
Right.
And it doesn't go as far as saying intoxicated people are dangerous, but there are cases that talk about, and scenarios that talk about, the mentally ill, violent people.
Sure.
Would intoxicating, that was kind of my earlier question. How general can we be? You said that have to be the twin. I read that language. How close does it have to be when we're looking at the historical analog in your mind?
Again, it does not have to be a twin. It has to be close. And to directly answer your Honor's question, contrary to the defendant's claim at this point in time, the state actually does believe that the mentally ill, that category of offenders that have been historically prohibited from bearing arms, we believe that is an actually functional equivalent here. This isn't, again, that we're talking about someone that is presently under the influence of alcohol to a degree that they could not safely operate a firearm. We're talking about a moment in time, very brief. And so as a result, we do believe that is comparable to someone that is mentally ill. The case at issue, I believe it's cited by defendant Harrison in their brief. I would encourage this court to take a look at that case. I would ask this court to take a look because it's been reversed and remanded. So there is absolutely no support for the defendant's arguments in this case.
What about, there are some other potential analogs, 1655 Virginia prohibition of shooting any guns at drinkering, and a 1771 New York law banning firing of guns on certain holidays are correlated with consumption of intoxicating substances. But one might suggest that there's a distinction between firing and possession, and question, that's the how, I guess, and why questions that we ask, and the why, whether those were to preserve gunpowder or to prevent false alarm of attack, as opposed to protecting public safety. How should we reconcile those lines of analogs?
The state would suggest again that we do not need a historical twin here. And I think that this court can look at those prior statutes, ordinances, and consider whether we're talking about just use or for what that use is for what that use is intended to prohibit, whether, again, as you know, preservation of gunpowder or public safety. Because what we're talking about, there is an analogy to be drawn that in those cases, they're talking about someone that has a gun in public and then arguably uses it. But there are, again, why can inform the analysis here, because what we're talking about is people in public that can't use a gun safely, even if they tried. And again, this statute, well, I haven't, not again, but this statute protects the right to use a gun to defend oneself still. So I think that can lend some support, not as much as the roughly 11 additional cases that the state has cited.
Thank you, Mr. Any other questions, call? Thank you, Mr. Gillette.
Thank you, Your Honors.
Mr. Reynolds.
Thank you. Good morning. Kelly Reynolds for the appellee Hunter Clift. Thank you for your time and may it please the court. Justice Rosen, I think you got right to the issue at the beginning of the state's oral argument here, asking what do we do with that? And you were inquiring.
You that's what you talk about in your brief. You really didn't address the district court's analysis. You kind of jumped into, not directly, but right for the wrong reason, and let's do the proper analysis. Is that kind of your position here this morning?
Yes, sir. The state's brief in its beginnings, the majority of it, I guess, was tearing apart the district court's analysis. And that's correct, Justice Rosen, it's not the correct analysis to be done here. I believe you have unlimited review of this issue as it's a constitutional issue. And I do believe that there's Kansas authority, as cited in my brief, that if we arrive at the correct result, it doesn't matter if the district court was erroneous, because you get to do this review and analysis independently.
So just our situation, I've sort of accurately positioned here. Our situation is that nobody likes what the district court did.
I will not say that,
Well, I mean,
Justice.
you like the outcome, you just don't like the way the district court connected the dots. Here's my problem. That approach that the district court used seems to tell me that you have a right to defend yourself with a firearm if you're drunk, if you're a domestic abuser, or if you're have a violent criminal history, that regardless of anything else, you've still got a right to defend yourself with your firearm. And don't we have to deal with that analysis first, if nothing else, to put it out of its misery, so that we can then get to the merits?
We do, Your Honor. And I believe that Heller and Bruin coming after it do address that there will be regulations of firearm use. There will be regulations of firearm possession. And a lot of these contemplate findings by courts. Findings by courts finding someone mentally ill, finding someone with a domestic violence tag, finding someone as a felon, which is a far cry from the type of statute we have here. But yes, there are times where there will be restrictions that are constitutional. So we see that. However, going back to the district court's analysis, we believe that they got to the correct result, but we believe the test is clear. The facial analysis, parsing of these tests, different tests, making them line up, Brunn is the correct analysis under Second Amendment jurisdiction, and under case law. And the Brunn analysis is simple. Well, none of them are simple, but it's very clear. It's a two-step analysis. I believe Justice Wall, perhaps you pointed out that the first step's met here, right? Justice Biles, thank you. The first step is met here. He's covered by the constitutional amendment, and therefore we get to the historical tradition, notably not historical example. Because a statute is old does not mean it's a historical tradition of firearm regulation in the way that we're contemplating here. Now, we do see numerous examples that have been pointed out. This one was from Justice Wall, I believe, about use versus possession, being able, the New Year's Eve revelers going abroad and firing their guns in celebration, specifically stated in numerous cases. That distinction is important here because Americans do have the right to armed self-defense. Now, again, there are reasonable exceptions to that, but this is not one of them. We have a statute here adding language that while in a vehicle, and it's perplexing why that specific portion of the statute is added in here. It does draw it more narrow. However,
Well, don't you think that's pretty clear? This statute was enacted in 2012, and I think if you just go to a basic history, this was all about firing firearms from moving vehicles, and there was the legislature was attempting to address circumstances when that occurs. So why is that? And it really does narrow the scope of. I mean, this is a pretty narrowly written statute. It talks about loaded firearms, immediate control in a vehicle, and being intoxicated to such a degree that you're incapable of safely operating a firearm. Those are pretty limiting circumstances, wouldn't you agree?
I would agree. Additionally, the statute carves out exceptions, including the mere transitory possession is an exception to the statute. It's drawn so specific, I don't see how it's rendered moot from its very language. But people should not have to pay for a defense to go and assert that the statute will always have a defense. Additionally, on its face, without getting to the facts, on its face under Bruin, this is not allowed.
Let me just ask, where are you finding the transitory language? C1, the exceptions are C1 and C2. Are you saying C2 is transitory?
It says the mere transitory use of a weapon, as long as it's carried out for no longer than is necessary. The specific citation, yes, C2. During an act committed in self-defense, and I say,
Right, so that's not really transitory. That again has to do with self-defense, right?
yes, Justice,
Okay.
and the transitory possession of a firearm is necessary. It's always for. It's arguable that it's always for self-defense. You cannot carry out self-defense unless you are possessing a firearm, at least armed self-defense. As far as the language of this statute goes, I believe that language makes it where this would never hold up on anything. Or there are numerous defenses that could attack this easily and early. However, under Bruin, we still believe it fails. Now, the state, Mr. Gillette stated that our client was more than twice the legal limit to operate a motor vehicle when this all occurred. However, he still had the good sense to immediately identify that there was a firearm there, that he had conceal and carry. So he had judgment enough to do that and judgment enough not to drive.
So did you raise in your motion to dismiss dismissal based on as applied? Because what you're talking about right now doesn't have to do with the facial challenge. It has to do with as applied to your clients.
Yes,
So do you believe that there was insufficient evidence that he was intoxicated to the point where he couldn't safely handle a gun?
I do. However, I don't believe we get there.
But was it raised in your motion to dismiss?
As applied was raised in our motion.
Okay, and did the district court rule on that?
They, as Mr. Gillette points out, the district court judge went through an overbreadth doctrine and a facial. I don't recall specifically. Well, he talked about the facts a lot, but the specific fact of him having a concealed carry, things of that nature, I don't believe were part of his holding or part of his rationale.
Did you challenge that? Did you ask for more specific findings to address your argument in your motion to dismiss?
I did not.
Thanks.
And could we just, in terms of the factual findings that partly you're relying on here in the record, there was no hearing held on this, was there, in terms of what's the state's position and what's your position? What are the facts? I mean, it's even disputed that there were more than one of the identified vehicles. The black Dodge Challenger, district court says there's two of them. The state says, no, that's wrong. There's facts that are vehemently contested here, and there was no hearing. So what do we do with that? And justice standards in a facial challenge, I guess that doesn't matter. But if we're going to get into the factual scenario, what do we do, or how do we handle that?
Thank you, Justice Rosen. And respectfully, I don't believe we get there. Now, we raised it, as pointed out by Justice Standridge, we raised it in our motion to dismiss. However, I don't believe we get there. We did not want to cede any point. We wanted to raise every point that we thought was valid. However, I think case law from the High Court of the Nation is clear. The only test is the two-step Bruin analysis. So we do not get to the facts. Now, I do not want to concede anything on my client's behalf because I do think he would have had valid defenses if we were to get there. But the argument central to today is under the Bruin two-step analysis, and I don't think we get to any factual analysis, Judge. But it is correct that there was no factual hearing or evidentiary hearing that took place. The judge ruled on the briefs that were submitted.
Thank you.
We also hear from the state regarding the mentally ill. Again, this contemplates findings by a court that could prohibit someone from carrying a firearm. Again,
Can I ask you, before you start talking about the analogs, there is a question of what is our relevant time period for assessing these analogs. And, you know, there's sort of this open question, I think, after Heller, Bruin, and Rahimi, whether that's 1791 versus 1868, when the 14th Amendment was ratified. And I think if you look at a lot of originalist scholarship, there's, you know, a pretty strong argument, at least in the literature, that 1868 is particularly the relevant focus when we're talking about Second Amendment challenges to state law provisions. Would you agree with that? Or if not, why is when we're looking for historical analogs, are we looking at, you know, Reconstruction, that sort of era versus founding?
Thank you, Your Honor. I would not agree with that. I think all time periods are open for you to review and look at because we're talking about a historical tradition, not historical examples from 200 years ago, 150 years ago. And I think what would be exemplifying of a historical tradition is seeing more statutes start to take shape across the nation that are congruent with the tradition, not examples piecemealed from across states that most of which aren't even existent anymore.
But would you agree that the case for tradition, at least at a surface level, looks stronger if you look at 1868 and a little bit forward rather than starting at founding?
I could see that. I think looking back to contemporary statutes, not the founding, but yes, at the time of the enactment of the Second Amendment, yes. But I think it would take some time for this to disseminate through the nation, and therefore emphasis on the word tradition and multiple statutes being enacted, this being on the minds of state legislatures across the nation. We have piecemealed examples. That does not create a tradition, especially when the majority of the examples do deal with firearm use while intoxicated or others being impaired in some other fashion that contemplate a court finding of such. So yes, Justice Wall, to your point, I think all time periods are important. And that's for a very specific reason, because we don't see these multiplying. We see them challenged. We don't see a lot of examples recently. And we have a lot more case law to go on. In Bruin, I believe 2022. And some of these cases are making their way up. But the tradition should be well established. As Mr. Gillette said, it does not have to be a mirror copy. It doesn't have to be a twin. But I believe the key language that can be glossed over is tradition. And therefore multiple statutes piggybacking off of each other or gaining knowledge from each other. Based
on your argument, would you also, what would happen to a statute that says that, probably our I don't know if we have a statute that says this, but for someone who has a mental illness?
Well, I believe we do have statutes that contemplate that. I know in care and treatment cases, I believe there's prohibitions against having a firearm if there's a finding that one is a danger to themselves or others. However, the key difference is this involves court intervention and a finding and due process. I mean, I don't believe there are field sobriety tests for operating a firearm.
But it goes to sufficiency of the evidence and an as-applied claim. We're talking about a facial challenge to a statute. Because under your, under your argument, I guess, wouldn't you also have to be arguing that that's unconstitutional also?
Well, Justice Sanders, what I believe would be the response to that for a specific example would be substance use disorders. You know, there being a specific finding about that. So we're involving findings here, and my comment on the as applied, as you phrased it, is just that there's already a finding in place whenever these people are encountered. You know, violent offenders or felons, mentally ill, substance use disorder. So yes, I think.
But you're comparing substance use disorder to, or I guess you're distinguishing substance use disorder from being drunk?
Well, in the sense that there's a finding for it and there's a diagnosable condition in the Diagnostic and Statistic Manual for Mental Disorders for substance use disorder, there are multiple layers of this being an actual finding or something more reliable upon, and not generalized to the general public who do have the right to armed self-defense.
Right, but that's all going to as applied. I don't understand your facial argument, because we're looking at a historical analog. And would you or would you not agree that there is a historical analog for mentally ill people?
I would agree.
Right. And so I think your colleague mentioned that that's pretty similar, as far as mind altering to being intoxicated.
Yes, but I believe those involve a court finding of someone being mentally ill. So that's how it's distinguished in our eyes.
What?
No, I was just, no, just,
No,
go ahead.
My question's fairly quick, but it's back to some of the prior discussion about where we look in history. And I just want to ask you about the language in Bruin and Rahimi, both of which say that the test is to, and I think I'm quoting here, apply faithfully the balance struck by the founding generation to modern circumstances. Doesn't that tell us we have to look to the founding generation?
I believe you can and should look to the founding generation, but I believe the language contemplated by the Supreme Court in Bruin is what I was discussing earlier as far as it becoming a historical tradition of firearm regulation. Yes, you can and should absolutely look to statutes from hundreds of years ago, but the mere presence of a statute existing then is not a historical tradition.
Okay.
Does it have to be a statute existing or a tradition?
It does not have to be a statute.
Like going armed is, and surety, those are not.
Right. So the common law can provide clarity, and I believe that's fair. And I believe it's fair to observe what the common law was trying to achieve there, and it's the use of a weapon, going armed or a fray. And that's what was being contemplated with those, which distinguishes it from being a tradition in the sense that mere possession of the firearm is what's being prohibited, which is the case here, which is unconstitutional.
And I just say, oh, did you have a question? So what do we do with, the Fifth and Fourth Circuit cases, which those circuits at least appear to me to have been more protective of the Second Amendment right than the Ninth or the Second Circuit? And both in Conley and in Daniels, they've rejected facial challenges to federal statutes, concluding that our history can support gun regulations disarming the presently intoxicated.
Well,
Do we have to? I mean, we have to, for your position to prevail, we have to disagree with that conclusion. But why is my question to you? Why were they wrong?
well, I can't remember the year in which Connolly was decided. However, we would concede that that language is not helpful to our position. However, it's more generalized and not as specific in dealing with a statute that's talking about mere possession in various situations, being in a vehicle. Now, there is a carve out for being at home here, but they are distinguishable in that sense that the exact statutory language is different. And what we are stating is that it's unconstitutional for it to be possession in a vehicle or on your person, just in general for the general public.
It appears both of you appearing here today have identified a test that you think ought to be applied, the Bruin analysis, Rahimi, that approach. Is that something we should do? I mean, we can, it's a legal question, it's a facial challenge. We could do that. Or is that something that should be sent back for argument and let the district court do it in the way that you both agree should be done?
I think you do the analysis under Bruin, and I think that takes care of the entire issue.
We do it, not the district court.
Correct. Thank you, Justice Rosen.
The entire issue, as I understand, when raised in the district court, included a state constitutional claim, correct?
Correct.
Do you believe that is still a live claim?
I do. We won't concede in any of our initial challenges, and I would note that the Kansas Constitution Bill of Rights in Section 4.
Yeah, we don't have to talk about that, but just procedurally to clarify, the only thing in front of us is the Second Amendment. But if we rule against you, it requires a remand to consider the other issues the district court didn't reach. Is that
Correct.
your position?
Yes, Justice Stiegel.
Thank you. Colleagues, any other questions? Okay, thank you, Mr. Reynolds.
Thank you for the court's time.
Mr. Willett, you reserve 4 minutes.
Thank you, Your Honors. I want to begin by immediately pushing back on Justice Stiegel, your question about whether or not we have to look at only the founding. The language from the United States Court in Rahimi is quite clear. The reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments. Goes on to say that by the same logic, the Second Amendment permits more than just those regulations identical to those found in 1791. And I would add on top of that, the recent federal case law that notes the 14th Amendment as being a particularly relevant time, 1868, and that regulations around that time are important. And that's important for a particular reason, because until that time in 1868, not all people in this country were people.
Right, I understand the argument. And I understand that your earlier quotation goes to the fact that there does not have to be a historical twin.
Correct.
But could you address the language I quoted earlier about, I mean, this is the court in both Bruin and Rahimi, I think Rahimi was quoting Bruin, explaining what this test is. And they say explicitly, this is about balance. This is about respecting the balance that the founding generation struck and applying it to modern circumstances.
And that's why that is my answer is that's why the 14th Amendment is important, because to balance with modern circumstances at the very first level requires all courts to consider what a person is under the Second Amendment, to whom the Second Amendment applies. And so until 1868, the Second Amendment didn't apply to all people in the United States. It's only then that a person to whom the Second Amendment could be applied was established clearly in our Constitution. And that's what the federal cases that the state has cited point out as well. So we have to look at both.
Go ahead, Justice Wall. That's fine.
Well, just to continue on that point, I don't know if you've seen it, but Rahimi, the first footnote in that decision seems to, they acknowledge that there's this ongoing debate in the literature between what's more important, the founding or 1868. They acknowledge that that is an ongoing question, but said that we're not going to address it because we don't have to in this case.
Right.
So is that still just an open question?
I think that there may be a little bit of room for fighting about that. And I would note that in Connolly, where that question was answered, the United States Supreme Court didn't touch it. they declined review as far as the state is aware. Now, the state, I will acknowledge that this is not, it's not in the record, and it's not in either party's brief, but there are continued ongoing debates about possession versus, or those with disorders versus those that just are presently under the influence. I believe there was a case that was taken up on a review just in the last week. I don't know where that will ultimately go, but as to the ongoing debate about which time we look at, I think that the argument is compelling that it has to include 1868. And I guess I would also note that and at least I think it was in Rahimi, there's at least an example that goes all the way back to England that talks about some of this stuff.
So we can go way back. What about the balance with modern circumstances?
Sure.
Modern circumstances, when our founding fathers were considering the Second Amendment and all the amendments, there weren't motor vehicles.
Correct.
There was no electricity. The firearms, I think, contemplated from then to now is different. I think we would all agree to that. How far can we go with the consideration of modern circumstances in balancing the historical tradition?
I think that this court can take into account all modern circumstances in trying to balance it with tradition. And as Your Honor noted, there are a number of things that come into play here. In addition to the extremely narrowly written statute here, we're talking about vehicles, we're talking about loaded weapons. The current times and the gun at issue in this case is a semi-automatic weapon that is far different than what existed at the time of our founding. So again, these are things because it changes the individual's ability to move about in public. It changes the level of risk to the public. Candidly, I think you could probably even consider alcohol. That has changed a whole lot since the time of our founding. And our ability to determine whether or not someone is under the influence.
I have one final question for me, at least. And often it doesn't matter, I suppose, but it might matter here. Do we apply a presumption of constitutionality to this statute?
I think the best way I have to answer that is to point to the correct test that's noted in Rahimi. It's not exactly a presumption that may exist in certain instances, because in this case, what is required as an initial step is for the state to demonstrate this historical tradition or similar analysis. And at that point, I think that the presumption can arise, because it is only at that point that the defendant is then required to demonstrate that there is no set of circumstances that exists. So yeah, I think to answer your question, yes, I think you can, number one, but number two, as this analysis proceeds, it's slightly different because this is a Second Amendment question, and that presumption could also arise through the application of the test here.
So, yeah, thank you, Justice Stegall. I wanted to clarify, do you agree you have the burden in a facial challenge under the Second Amendment?
We agree that we have an initial burden. We believe that burden was carried here. Had we had the opportunity to actually proceed to a hearing, we would have been able to further establish that burden was carried. Candidly, I think this court can look at the district court's ruling here, and whether the district court recognized it or not, it acknowledged the state carried that burden and then failed to hold the defendant to his. All right. If there are no further questions, the state would respectfully ask this court reverse and remand to the district court for further proceedings on the remainder of defendant's claims.
Any other questions, colleagues? Thank you, Mr. Gillette, and
Thank you.
thank you both for your arguments this morning.